Question 1. Elena, who careered as an accountant for more than 2 decades, has been employed as the director of TEDx Berhad, an investment company. In discharge one of her mandate, she is required to prepare the financial statement according to the basic statement guideline and framework. Elena, however, had a negligently prepared such document where it involved a series of major misstatements and miscalculations. This would never not be expected from Elena, who was deemed to have a vast experience in the practice. Following a hard loss and setback, the company had dismissed Elena and sued her for damage, advised Elena accordingly. Issue whether TEDx Berhad can sue Elena. Law, Section 135 of the Contract Act 1950, an agent is a person employed to do any act for another or to represent another is dealings with a third person. The person for whom such act is done or who is so represent is called the principal. Section 165, the Contract Act 1950. An agent is bound of the conduct the business of the agents with as much skill as it are generally processed by person agents engaged in a similar business unless the principal has a notice of his want of skill. The agent is always bound to act with responsible diligence and use such skill as a processes and to make compensations to his principals in respect of the direct consequences of his own neglect, want of skill, or make misconduct, but not in respect of loss or damage which are evidently or remotely caused by such negligently want of skill or misconduct.
The case that related to the question is Keppel versus Wheeler, 1927. The fact is, in this case, the defendant was an agent for the plaintiff. The agent was asked by the plaintiff to sell a house. One offer was made by A through the agent, and it was accepted by the principal subject to a condition. Later, another offer was made by B, but this time the offer is higher than the first offer made by A. The agent did not inform the principal about B's offer. Principal signed the contract with A, and the principal took an action against agent. Further help was liable to plaintiff. For help, the defendant was liable to the plaintiff for the difference between the two offers. The inference in the agent must disclose everything coming to his knowledge which is likely to influence the principal in the making of the contract. For the application, applying into the Section 135 of the Contract Act 1950 deals with the liability of a person as principal for acts of agent. In Elena's case, if she acted negligently as a director, she could be held personally liable for any damage resulting from her actions. It's important for Elena to seek legal counsel to understand her rights and responsibilities in this situation and to defend herself against the lawsuit filed by TEDx Berhad. She should gather all relevant documents and evidence to support her case and be prepared to negotiate and litigate as necessary. For the conclusion, TEDx Berhad can potentially sue Elena for damages resulting from her negligent preparation of financial statement.
Next is question 2. Eden wanted to sell his Range Rover to any interested party in order to raise his personal fund. Through an advertisement, he had coincidentally met his old friend Danny on 24 April 2024, who agreed to buy at the price of 750,000 ringgit. Convinced that Danny will settle the payment in full on 1st May 2024, Eden had immediately transferred the car to Danny on the same day. Unfortunately, there was no any payment effect on 1st May 2024, and Eden therefore realized that he had been cheated. Eden tried to claim his car from Danny on the next day, but only to discover that it had been sold to Lisa, a third party who bought in a good faith, advised Eden accordingly. The issue is whether Eden can claim his car from Lisa. Provision. Section 2 of the Sale of Goods Act 1957. Goods mean every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass and things attached to or forming part of the land which are agreed to be sold before sale or under the contract of sales. Section 20 of the Sale of Goods Act 1957, where there are an unconditional contract for the sale of specific goods in a deliverable state, the property in goods passes to the buyer when the contract is made, and it is immaterial whether the time of payment of the price or the time of delivery of goods or both is postponed. General rule: Demo dat quod non habet means no one can transfer a better title than he had himself. Exception: Sale by buyer in possession after sales. Section 30, subsection 2 of the Sale of Goods Act 1957, where a person having bought or agreed to buy goods obtains with the consent of the seller possession of the goods, of the documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of title under any sales, pledge or other possession thereof to any person receiving the same in good faith and without notice of any line or other right of the original seller in respect of the goods shall have effect as if such line or right did not exist.
Case: Newton Wembley Agility. Fact: Plaintiff, the true owner, sold the car to the first buyer. Payment was made by check. It was agreed between the parties that the title would only pass when the check was honest, but the plaintiff had been given possession of the car to the first buyer. The first buyer subsequently sold the car to the second buyer, who in turn sold it to the defendant. The check was dissolved and plaintiff attempted to recover the car from the defendants. Help: The first buyer, who was in possession of the car with consent of the true owner, could pass a good title to the second buyer, who in turn transferred it to the defendant. Plaintiff action fell. He could only claim the price from the first buyer. Applications: Applying into Section 30, Subsection 2 of the Sales of Goods Act 1957 deal with the transfer of properties in goods sold. In Eden's case, since he transferred the car to Danny without receiving payment, the property in the car did not pass to Danny. Therefore, Eden still retains ownership of the car and can rightfully claim it back from Danny. However, since Danny sold the car to Lisa, who bought it in good faith, Eden's claim against Lisa might be more complicated. Eden should seek legal advice to understand his right and option for reclaiming his car from both Danny and Lisa. Conclusion: In this situation, Eden might have a legal right to reclaim his car from Lisa, depending on the law of the jurisdiction where this occurs. Generally, if Eden can prove that he did not receive payment from Danny and that he transferred the car under the bill that he would receive payment. He may give grant to reclaim the car from Visa. However, no regarding the right of incorrect third parties who purchase goods in good faith vary with jurisdiction.